Welcome to today's program titled Returning to Business in Illinois, Unique Challenges for Companies Operating in Illinois. At this time, all participants are in a listen-only mode. For those of you logged into the web presentation, you're encouraged to submit questions throughout the conference by typing them into the text box on your computer screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. When you hear this code, please write this code down. It will not be reread, and it is required for the CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the following days following the webinar. At this time, I would like to turn the conference over to Ms. Jennifer Kraft. Please go ahead, ma'am.
Thank you, and welcome everyone to our discussion on challenges companies face when reopening in the state of Illinois. My name is Jennifer Kraft. I'm a partner in our Employee Benefits Practice Group at Seyfarth Shaw's Chicago office. Before we get started today, I'd like to take a moment to address the deeply distressing events that are unfolding in our country. My colleagues and I share the horror and dismay that many of you feel when witnessing acts of racially motivated violence against our fellow humans. The violence only makes things more difficult for our community and a population that has been disproportionately affected by COVID-19. While our presentation is focused on returning to business through the COVID-19 pandemic, the events that have occurred over the last week will also affect companies reopening across the nation, but certainly in Chicago and throughout Illinois. We're going to touch on a few of these points today, but we encourage discussions and questions related to these tragic events, whether related to reopening your business, how you can better cultivate diversity, or our own inclusion efforts as a firm. Now, for a few housekeeping matters about the webinar itself, as our host indicated, for those of you seeking CLE credit, we'll announce the CLE code towards the end of the presentation, and a CLE form will be emailed to you following today's program that you'll need to use to write down that code, so make sure you write it down. Also, a quick note that throughout the presentation, our speakers will be asking some polling questions. So due to time restrictions, we're not going to be able to show the results live, but we will collect the answers and provide the answers to you in a follow-up email, and your answers will be reported anonymously. So they may not all apply to you, but please answer what you can, and it will be interesting to get that information back. Finally, if time permits, we're going to address some questions at the end of the program, so feel free to submit those online as well throughout the webinar itself. So with that, we will kick off. I am very happy to be joined today by four of my colleagues in our Chicago office. And our goal is to provide you with an overview of things employers should be thinking about as we enter into this next phase of returning to business. I am joined today by my colleague Sarah Fowler of our Labor and Employment Group, Susie Saxman from our Corporate Group, Christine Argentine from our Litigation Group, and Toby Pinsky from our Real Estate Group. All of these attorneys have been fielding questions from a variety of companies throughout the COVID-19 pandemic and helping businesses navigate through this time of uncertainty and constant change. So you are in very good hands listening to all of these folks on their various areas of expertise. Our agenda today, we're going to start with just a very high-level overview of the reopening guidance from both at a state and statewide level and for the city of Chicago. Then we'll move into some employment law issues. We'll touch on some employee benefits issues. Then we'll get into managing the business stimulus options and resources available, consumer-related liability, and finally, guidance to commercial landlords and tenants. So to start with kind of where we are from a legal perspective, Governor Pritzker issued an executive order last week, which was moving most of Illinois into phase 3 of the state's reopening plans. And in that executive order, it goes through a number of requirements for individuals as well as businesses, and there's lots of guidance related to the businesses themselves. We'll just There's a lot of detail on these slides. I'm going to go through it at a very high level, but the slides will be available after the presentation, so you'll have those as a reference. In general, for individuals, the requirements are that we continue to practice social distancing, so that's staying 6 feet away from those who aren't in your household, wearing face coverings in public places or when working. It also indicates elderly people or those who may be more vulnerable due to illness are still urged to take special precautions and minimize their in-person contact. Gatherings are limited to 10 people or less, and there's an encouragement of conducting activities outdoors when possible, since the studies indicate, or science indicates, that the COVID-19 virus does not travel as well outdoors. The requirements for all business, the executive order provides general requirements that apply to all businesses, and then it gets into some very specific details related on different industries. And that specific guidance is available at the website link there. The Department of Commerce and Economic Opportunity in Illinois has issued very specific guidance related to each industry. So again, the kind of general things that apply to everybody is that we should still be considering if people can do their jobs at home and facilitate remote working when possible. The same sort of practices related to social distancing and face coverings apply. Also, employers should be thinking about their spaces and trying to allow for social distancing in common areas like lunchrooms and locker rooms. Same sort of thing with visitors, thinking about social distancing there, and there are also some posting requirements that are required. These next several slides get into some of the more detailed provisions for various industries, and I'll say that the DCEO has guidance and kind of these business toolkits for 10 different types of areas of industry for retail and manufacturers, which are seen here, office buildings, restaurants and bars. The types of things you're seeing, it's consistent themes of 6-foot social distancing, wearing masks, and various things related to restaurants and bars, for example, in limiting capacity. And those sorts of details are all set forth in the guidance on the DCEO's website. Same with fitness and exercise gyms. There's some specific requirements related to what's permitted in those industries, and personal service facilities and outdoor recreation and youth areas. Again, we encourage you to go to the state's website, the DCEO website, to get specific details, and we'll touch on some of those as we go throughout the presentation today as well, but just to kind of set the stage. The city of Chicago has announced, as many of you know, has announced a delayed effective date for the phase 3, moving into phase 3. Last week, Mayor Lightfoot had announced that Chicago could move into phase 3 and these types of precautions on June 3rd. And as recently, over the weekend, we've obviously had a lot going on in the city. There was some talk of perhaps that June 3rd date would get bumped out. But as recently as this afternoon, Mayor Lightfoot has said that she is planning on moving forward with the June 3rd opening, which is tomorrow, based on what she's been out in the field speaking to business owners, and has decided to move forward with that. So the same sorts of things will apply. The city of Chicago has its own limitations as well, but the same sort of thing where we're going to be returning to work for non-essential workers, social distancing and face covering, and keeping those social gatherings limited to fewer than 10 people. So at the very high level where things are at, I'm going to turn the presentation over to my colleague Sarah Fowler now. We'll start to get into the details a little bit more about what all of these rules mean and kind of get into the nitty-gritty of some of it. So I'll turn it over to Sarah. Sarah?
Thank you, Jen. When it comes to returning to business, there are a host of labor and employment issues to be thinking about, many of which could have and frankly have had their own complete webinars. So with our time today, we're going to focus on 4 key areas to be thinking about as you prepare to resume operations. First, we're going to talk about considerations for your return to work plans, employee testing and screening. Then we'll go into leaves and accommodations, and finish up with talking about some particular Chicago laws to be mindful of. So let's begin. And as you prepare and refine your return to work plans, you need to determine the current universe of laws and ordinances to be concerned with and arm yourself with the relevant requirements and tools that apply to you and your business. It's also important to be mindful of recommendations from state and local departments of health. Many orders, like Illinois, reference following public health guidance, so if those change, you need to make sure you're being flexible there as well. We want to think about what universe of leave laws might be applicable as we return our employees to work as well. If you're a union employer, determining whether there's a need to bargain with any unions about additional workplace health and safety protocols or other changes to policies and practices. And finally, if you're in a particular industry, as Jen noted, you'll definitely want to make sure that you're gathering the applicable industry guidance and recommendations. And that can be from government mandates and from industry specialists as well to follow best practices. So applying those principles here in Illinois, we do want to be mindful of what the CDC is putting out on a federal level. Those are recommendations. They're not mandates, but we certainly encourage our clients to review them, adhere to them, and keep up with their current best practices. And as Jen noted, we have our Illinois orders and guidelines, as well as Chicago. Now, the state's business guidance documents from the Department of Commerce and Economic Opportunity, the DCEO that you've probably seen at this point, they're phrased as minimum guidelines and encouraged best practices. And if you're like me, you may be scratching your head wondering about what a minimum guideline is. Is it a floor we must follow? Is it merely a guide? And to add confusion to that, the governor's order from Friday on May 29th and the DCEO's FAQs talk in certain places about requirements for businesses, and then in other places use more permissive language, like employers should. So they're certainly not making this as clear cut as it could be for us. And while there is an argument that the guidelines are required, the permissive language leads us to believe that these are recommendations, which businesses should certainly strive to follow to the extent practicable. And you do want to keep in mind that if there are conflicting requirements between the federal, state, and local, to generally go with the most restrictive requirement where possible. Once you have your universe of applicable mandates, we want to think through what categories should be included in your return to work plan. And at a high level, these are some of the categories you'll want to think about and include in any plan you're implementing here in Illinois. As you can see, it runs the gamut from your health and safety issues like behaviors and supplies to promote cleanliness, to your physical workspace, your employment policies, and staffing issues. To do this, you may need to align with contractors or other third parties, like in cleaning, to make sure that the processes are being adhered to. And to borrow from what the CDC has published in its guidance, these really necessitate changing the way we work. And many of you are already on the forefront with that, but it's worth emphasizing as you prepare and refine these plans to, quote, return, the reality is we're not returning to the places that we left. We are quite literally changing the way we work. And now we have our first poll of the presentation. You can answer yes, no on your polling. Have you prepared a return to work plan? With these principles in mind, these are some key elements to include in a return to work plan, specifically in Illinois and the Chicagoland area for compliance. Keep in mind that there may be more restrictions applicable if you're in a retail, manufacturing, or other specific industry. But as Jen noted at the beginning, even though we're reopening, the guidance and directives all say that employers should continue to facilitate remote work where possible. Social distancing is really the name of the game. That means putting up the signage to help people with social distancing, making sure that your physical spaces are conducive to social distancing. It may mean limiting use on common spaces. There are posters that should be put up to remind employees of these issues as well. And where social distancing is not possible, employees should be wearing facial coverings, which should be provided to them. We want to make sure that there's an adequate supply of tools for hand washing and hand sanitizing at work. And you want to make sure that you're implementing health screening programs, making sure that you have a plan in place to keep symptomatic employees out of the workplace. And on this next slide, we included some of the current guidance that may be of interest to you as you're reviewing and refining your return to work plans. Before we move past the general return to work planning, a brief note about updating workplace policies. Updating policies is generally something we often intend to do and can fall by the wayside, but you do want to ensure that your policies and handbooks reflect the new landscape and that all of your pieces fit together. There may be new policies and protocols that should be memorialized if they haven't been already. The Families First Coronavirus Response Act, which we affectionately call FFCRA. If you're a covered employer under that, making sure you have a policy for that type of leave, for visitor protocols, infectious disease policies, testing if you're doing that. And then you'll want to think about your existing policies and whether they need to be amended, either temporarily or otherwise, in light of COVID. Things like remote work, expense reimbursement. Do your job descriptions need to change? Do any processes need to be adjusted given the parameters of the COVID crisis? Now we're going to talk about employee screening and testing. And when I say screening, I'm referring to asking employees questions or monitoring employees for symptoms to keep those who may have COVID-19 out of the workplace. Testing, on the other hand, refers to actually facilitating the medical examination and diagnostic testing for COVID. Testing is not required by any of the Illinois or Chicago orders, but employers can generally require employees to be tested for the virus as a condition of returning to work if they choose. With respect to screening, it is generally recommended. Illinois' Department of Commerce's minimum guidelines include guidance for screening. For office and retail employees, for example, it states that employers should have thermometers available for use and should screen employees in person before they come into the office, as well as mid-shift, either virtually or in person. And the CDC recommends screening as well. Illinois has published a symptom form on its website that may be useful to have your employees fill out and check whether they're experiencing any COVID-related symptoms. But do keep in mind that the symptoms have changed throughout this COVID crisis, so you'll want to make sure that you're always using the current recommended symptom and screening checks. Temperature checks. In the context of this pandemic, it is permissible to take employee temperatures, but employers must make sure to keep that information, as you would all screening information, confidentially, like other employee medical information. You can have employees take their own temperatures and self-certify, or you can have the temperatures taken on site. And be mindful, though, that time spent with screening is likely compensable for non-exempt employees. And finally, in considering whether to screen employees for temperatures, you just want to be thinking about the limits to temperature checking. Not all individuals who have COVID have fevers, and not all people who have fevers have COVID. So there are limits to the usefulness of that information. Testing guidance and considerations. So some employers are going a step beyond screening and requiring employees to be tested for the virus. Now, there is a distinction between testing for the virus itself. Is this person currently infected and contagious? And there's also antibody testing or serology testing. The EEOC has said that testing to determine if employees have the virus is generally permissible, as it's designed to protect against a direct threat in the workplace. It has not offered specific guidance as to antibody testing. And recently, there's been some concern about the utility of antibody testing. The CDC has issued guidance specifically saying that it should not be used in any return to work decisions. So at minimum, employers who are interested in antibody testing should carefully think through the pros and cons of that approach and how that information would be used. Any testing that you conduct must be done using reliable and accurate methods, maintaining employee confidentiality. And keep in mind that reasonable accommodations may be needed. If an employee requests one, you should engage with them in the interactive process as you would with any other reasonable accommodation request. Speaking of accommodation requests, we're going to move into COVID-19 leaves and accommodations. We expect to see many more requests for accommodations as employees return to work. And while the process and legal principles are generally the same, there are a few unique aspects of COVID worth noting here. Most importantly, that's to understand whether the ADA accommodation process has been triggered at all, such that you have the legal duty to engage in the interactive process. Not every request is going to be an ADA accommodation. And that's not to say from an employee relations standpoint that you should disregard it, but the legal requirements will certainly be different. So should we be thinking about, is this a general fear about someone returning to work, for example? Without any tie to a medical condition or disability, that would not likely trigger the ADA interactive process. But keep in mind that expressing a general fear about COVID could be a manifestation of a disability, like anxiety or depression. We hear a lot about age lately. There's not a legal duty to accommodate someone based on age per se, but given that being over age 65 is associated with higher risk, We encourage employers to engage in the interactive process with those workers who request an accommodation on that basis. What about someone who has a family member who's considered high risk? Well, there's no legal obligation to accommodate an employee because their household family member is considered vulnerable or high risk, just like there wouldn't be a duty to accommodate someone whose family member has a disability, but leave may be available depending on that situation. Pregnancy is an area, however, where you should engage in the interactive process with any employee requesting an accommodation. Illinois specifically requires accommodations for pregnant employees. If you do find yourself in the interactive process being triggered, you should generally follow your normal processes with adjustments as needed for COVID. That may mean meeting virtually, using Zoom or your other virtual connectivity method, relaxing medical certification requirements as appropriate. And we've included a list of some potential COVID-specific accommodations, but as always, you'll want to consider each situation on an individualized basis. Keep in mind that leave, at least in some fashion, can be a reasonable accommodation, but the better practice is to find a way that will allow employees to resume work. And where leave is available, like the traditional FMLA, like the FFCRA, or other paid sick leave, keep in mind that those are entitlements, and they're outside the interactive process obligations, and if someone meets the qualification standards, they are entitled to that leave. So let's think about some interesting situations that we may see as we return to work. What about an employee who just refuses to come to work at all? Well, that could have many different permutations. We'd want to, of course, sit down with that person, have a conversation, maybe not sit down in person, of course, and talk about why they don't want to come to work. Is this an accommodation issue that we need to treat as part of the ADA interactive process? Or do we simply need to have a conversation about what the company is doing to make the work environment safe for its employees? If there is no ADA issue and there's no leave available or triggered, if there's no legitimate safety issue that's being raised, at the end of the day, you do have a right to expect your employees to come to work, and you may be able to proceed with separation. But that should be done in consultation with counsel to make sure that you're protected, given the many minefields of retaliation claims that could relate to COVID. What about an employee who approaches you complaining that their coworker has been coughing? We may see a lot of this. And you'll need to balance workplace safety on the one hand, ensuring that your screening processes work, that employees who may be contagious are not at work, but also ensuring that those who can work are able to do so, are not treated adversely for any manifestations of a disability, for example. This situation also could be a veritable law school hypo, but in a nutshell, you'd want to do your due diligence and look into this further, being cautious and not asking any impermissible medical questions. Maybe the employee does need to be out of work for a while. Maybe they need a clearance to return to work so we could feel comfortable that they should be there. If you do get assurances that it's safe for this coughing employee to be at work, maybe that person has an asthmatic cough, for example, you'll want to manage the employee relations issues there going forward while treating the medical issues confidential. Now, what about an employee's child's camp has been closed just as you're about to resume your in-person operations? Also likely to be a popular issue. And while there's not an accommodation duty to care for an employee's child per se, if you're an FFCRA covered employer, that would cover closure of the child's camp. Presumably there's an implied presumption that the employee did enroll their child in camp to begin with. But we don't want to assume that simply because someone hasn't taken FFCRA leave up to this point during the school year that they're not entitled to the leave. There could be other explanations for that. Our last polling question of this segment: what's the most challenging aspect of managing your return to business employment law issues? And finally, we are going to talk about a few Chicago-specific ordinances with specific COVID implications. Chicago has a new anti-retaliation ordinance that became effective May 20th. Employers cannot demote or terminate an employee for obeying an order issued by the mayor, the governor, Chicago Department of Public Health, or a healthcare provider as a general matter to stay at home, quarantine, isolate, or to care for a family member who is so ordered. So this is an example where there may not be a specific legal duty to accommodate someone who needs to care for a family member, but there are limits on adverse actions if someone says they cannot come into work for one of those covered reasons. We also want to be mindful of the Chicago and Cook County paid sick leave laws. In addition to using those for illness reasons, employees can use them when their workplace is closed or their child's school is closed due to a public health emergency. And finally, Chicago's Fair Workweek law will be going into effect on July 1st. If you're a covered employer under that ordinance, there could be requirements to compensate employees for certain schedule changes as you resume work. But if the schedule changes are specifically related to COVID, there would generally be an exception to that predictability pay requirement. Now, finally, before I hand it back over to Jen, I wanted to let you all know that our training affiliate, Seyfarth at Work, is launching a return to work e-training program to help your employees on the new requirements as they return to work. Information on that will be sent out after the program. And with that, back over to Jen for employee benefit considerations.
All right, thank you, Sarah. In the employee benefit space, there's generally two areas that we think about for as employees are returning to work. Number one, have there been any changes since they've been out? Do we need to adjust anything with their benefits? How do we want to treat that time away? And then secondly, whether you're adopting anything related to the legislative or agency guidance changes that have come out recently. So we'll just touch on all of those at a very high level, and we do have alerts and blog posts available on our COVID-19 Resource Center online that go into all of these areas in more detail. On the retirement side, if somebody is returning to work because they've been furloughed, perhaps on an unpaid leave, or if they're rehired, we want to look at what impact that would have on their deferrals in the 401k plan or any loans they may have in the 401k plan. So the plan may provide, if you're not on an unpaid leave, and administratively those deferrals just carry through. Loans, we'd want to look at whether their payments have been suspended because they were on an unpaid leave, and whether there's a need to re-amortize some of those loans. So part of that's going to be looking at your plan documents and then dealing with your record keepers to see, make sure there's no glitches in that return. Another consideration is whether the 401k plan is going to adopt any of the CARES Act distributions or loan relief that was made available by the CARES Act. And one of those provisions is you can add a new CARES Act distribution that lets people take an in-service distribution of up to $100,000 through the end of 2020. That is, for the participant, it can be considered taxable income over 3 years. They can spread it out. In order to be eligible to take that distribution, somebody needs to be a qualified individual, which means they've been diagnosed with COVID, or their employee or spouse, the spouse or dependent was diagnosed with COVID, or they've had some adverse financial consequences from COVID, either due to quarantine or layoffs. So it's a pretty broad definition. These are optional provisions if you would like to permit this CARES Act distribution or loan relief, something to think about for employers. Another issue for those of you that have pension plans is to think about how that time away from work is considered for purposes of the pension plan, or quite frankly for service under the 401k plan as well. It'll depend on if they were actually terminated or unpaid leave. And there's also, from the pension side, if you desire, you could amend the plan to change how it to provide for additional service if the plan would not provide for service during that unpaid leave. You also may want to consider if there's final average pay formulas, if you want to exclude this furlough period. Those are all optional changes to enhance folks' benefits and would not be legally required, but could be considered. On the health and welfare side, if people have been out, you want to think about whether they were covered under the medical plan or other health and welfare benefits while they were out, and if they were paying for that coverage, if they were sending in payments, or perhaps the company paid for them with the idea that they would recoup and kind of catch up those contributions when they come back. So thinking about collecting on those arrearages, looking at your plan language for what's possible there, as well as some wage and hour considerations. We want to make sure we're not getting below minimum wage in what we're deducting if we're kind of catching up people for those deductions while they were out. If employees lost eligibility for coverage while they were out, we want to provide an opportunity for re-enrollment. There are also some new changes under IRS guidance that permit some changes that will let people, let plan sponsors to amend their plans to add new enrollment opportunities, to add new enrollment for the employee or perhaps the dependent mid-year. to permit changes in flexible spending accounts. A lot of those changes are subject to, typically they're subject to the code section 125 rules, and it's very limited as to when you can change mid-year. But this new IRS guidance has provided new opportunities for companies to consider for their flexible spending accounts. Those are optional and you don't need to allow them, but something to consider. Another thing, again, from the service standpoint to think about is break-in service rules under the Affordable Care Act. If somebody has been out and not credited with an hour of service for 13 or more weeks, they could be treated as a new employee for Affordable Care Act purposes. So some thought to be given to how your eligibility works and whether how your plan rules work to see if those types of rules would apply. A quick polling question here is asking, are you implementing any of these new optional changes for welfare plans to permit new enrollments mid-year or to permit changes in the flexible spending account? So let us know about that. With that, I'm going to turn things over to Susie Saxman to talk through some of the corporate considerations from returning to business. Susie?
Thanks a lot, Jen. Hi, everybody. I'm going to try to cover a number of corporate and commercial items really at a high level. Most of these are not state-specific, and in fact, most of them really relate just to general commercial opportunities and perhaps business stimulus programs that are available at the federal level. Let me first mention our CLE code. It is SS 6562. That's SS as in Seyfarth Shaw 6562. I also want to just mention that on our COVID-19 Resource Center at our Seyfarth website, you will find a lot of corporate legal updates, including just last night we released another legal update on the Main Street Lending Program terms and conditions. So please feel free to join us there. Just at a high level in terms of economic stimulus, loan and forgiveness programs, probably the single biggest program we've spent the last 2 months on is the PPP, the Paycheck Protection Program. This was authorized by the CARES Act, adopted on March 27th. April 4th was the first day that applications were accepted. It was a bit of a work in progress. Some applications went more smoothly with some banks as opposed to others. But in any event, we're 2 months into the Paycheck Protection Program, and we know that the $349 billion originally appropriated was used up, committed in about 2.5 weeks. Subsequently, unfortunately, another $310 billion for a total of approximately $660 billion was appropriated for additional loans. At this moment, the information that we've seen is that there is approximately $140 billion still uncommitted, and as of now, the program is still open for applications through June 30th. We would, urge you to take advantage of these programs if you are eligible. The PPP in particular is a program primarily focused on providing working capital to small companies, small businesses, in order primarily to support payroll. The amount of your loan is based at a very high level, roughly at 2.5 times your average monthly payroll during 2019. And again, this is all kind of a very generalized statement. The average size of a PPP loan is about $103,000. But I can tell you that the loans in groups of related companies who still remain eligible can go as high as $20 million. We have recently seen through some of the FAQs that have been issued by the Federal Reserve and the SBA that they are putting a cap on any consolidated group at $20 million. We've seen quite a lot of loans between, say, $2 million and $10 million. Out there, again, still companies who are able to meet the eligibility requirements. Now, we have counseled thousands and thousands of clients and companies who are navigating the PPP application process, but right now in particular, they are managing the loan forgiveness part of this program. The one unique feature of a PPP loan is if you are using your proceeds in a certain manner that meets the loan forgiveness guidelines, you can apply for loan forgiveness. At the current moment, under the Act as established on March 27th, if during your covered period, which today is the 8-week period which begins on the date your loan is dispersed, if you are able to use an amount of the proceeds, at least 75% of which are used for payroll, and you have a little bit in terms of option for how you configure either payroll on an accrual basis related to that period, or perhaps sync up your normal payroll reporting process. A little bit of flexibility has been provided. But if you spend at least 75% on payroll, with the balance of 25% being spent on other eligible disbursements, including things like rent, mortgage interest for pre-existing mortgages, utilities such as gas, electric, telephone, internet. We've received lots and lots of questions about whether any of those categories will be expanded. But if you're able to do that, you don't have to apply for loan forgiveness for your full loan. You can take the portion of your loan of which at least 75% was able to be used for payroll and apply for forgiveness for that part of your loan. And assuming that it's granted, that effectively turns that portion, and we hope for many of you it will be all, into a grant. When you're in the loan forgiveness process, the SBA recently released Form 3508. It's available on the SBA's website. You can link to it on the Federal Reserve website. It gives you a form and instructions that will allow you to go through almost really a calculator of, am I eligible? Are there any factors that are going to curtail or reduce a portion of my forgiveness? And then finally, we've got many companies that we've talked to who are very focused on the ability to reverse any reduction in loan forgiveness by rehiring furloughed employees no later than June 30th. Now, if you didn't think that was confusing enough, last week on May 28th, late into the evening, which is the only time that anything important happens, including literally every interim rule, application, announcement that seems to come out of the federal government. But late on May 28th, the House passed in a near unanimous vote the PPP Flexibility Act. This legislation would add flexibility to the loan forgiveness requirements. For example, instead of looking at the 8-week covered period to see if you're eligible for loan forgiveness, there could be an extension to 24 weeks. Instead of having a 75% bar for payroll, you'd have a 60% bar. And there are a number of other things in this act, I mean, really almost too many to even go through now. And all I can say is that while in some respects the flexibility is great, but on the other hand, for all of you out there who are either well into your covered period, or you've spent your loan proceeds, or you've put your plans in place, for some folks, having this Flexibility Act passed is really not going to make things better. It's going to make it probably more confusing. So stay tuned and follow on both the SBA website and the Federal Reserve website exactly what kinds of updates that we may be seeing in the coming weeks. I'm going to issue a poll question. If you can take a look on your screen, does your business have a PPP loan? We'd be interested in hearing from you. We know that the SBA is circulating information on the apportionment of those loans among the 50 states, across industries, and also providing information on the size of lenders and the average size of the loan. So that's quite interesting. A couple of other things I'm going to try to touch on quickly because we still have a lot of content. Make sure that you're paying attention to potential tax benefits. There are both credits and deferrals that may be available to you. We just note a couple of the items under the Families First Coronavirus Response Act. There may also be the qualified wages and the retention credit that you could be eligible for. Now, that middle credit, you're not eligible for that if you're a PPP borrower. And then finally, the payroll tax deferral that's available until such time as your PPP loan is forgiven, or for a longer period of time if you're not a PPP borrower. So pay attention to that. Finally, managing the new filing dates for tax filings and payments at the federal level at a minimum. The April 15th deadline was extended to July 15th, and I would not be surprised if there was further action on that as well. Next, I don't want to say a lot about this. I think Christine Argentine may comment a little bit on business interruption insurance. We've gotten a lot of calls from clients about business interruption policies and whether they have good claims. We do know that there is significant litigation across the country relating to claims being made against business interruption carriers. The over 100 that are pending in federal court very possibly will be consolidated. There are lots and lots more that are being filed at the state level. We are seeing a lot of firms that take these on a contingency basis, handling these claims. And really, it's really looking at the issue of whether or not just this novel coronavirus is itself what created a physical loss that triggers insurance coverage. Many of the policies are different, so your policy is critical. Now, at least 7 states, and this was led by New Jersey, either have legislation or bills that are looking to stop carriers from rejecting claims. So there's going to be more information on this, I am quite sure, and it will be interesting. Another complicating factor quickly is that with the recent riots and protests that have taken place, there's been considerable business interruption that in the normal course should be covered by your policy. So if you went to your carrier once, please go again if you've experienced loss in that regard. A couple of other things quickly. Now's a time where, from a risk management point of view and from a cost-cutting point of view, we urge you to look at some of your contracts and financial commitments, determine whether you do have flexibility to modify or terminate. You may be able to reduce long-term commitments. There may be ways to restructure your contracts, modify based upon performance issues, voluntary or involuntary. Every state tends to have a slightly different take on force majeure. And then finally, there could be affirmative defenses that you have. Again, quickly, credit and liquidity. Independent of the PPP, your existing bank relationships may be available for further credit. The Main Street Lending Program is finally starting to get into place. We released an update last night on our resource center with an analysis of all 3 term sheets for the 3 different programs and the various documentation that will be required. This is something that anyone with 15,000 or fewer employees or $5 billion or less in 2019 annual revenue can take advantage of. There are some restrictions. Contact your private lender. Next, quickly on the corporate governance, we really encourage you, even though we're all very disconnected, there are a lot of difficult decisions being made. Many companies face this on the corporate governance side. Get your records in shape. We know from PPP, they're telling you to retain records for 6 years. They're going to look for a record of careful analysis and thoughtful good faith certification. So that's something to be aware of. And then finally, one last thing that we've seen is some preliminary steps toward restructuring of companies. There are some relief measures that are in place under the Bankruptcy Act, trying to make sure you manage your payments so that you don't get trapped into a possible preference exposure. And then finally, we have actually started to see a little bit of opportunistic distressed acquisitions, primarily small dedicated amounts of specific assets or a specific workforce, maybe a skilled workforce in place that another company is willing to cut loose. And of course, we're happy to chat with you about that, as well as provide some useful advice on taking out a rep and warranty insurance policy if that helps mitigate your risk. And that is it. I'm going to turn it over to Christine Argentine.
Thanks, Susie. So I'm going to just be addressing kind of at a very high level the risks that may be associated with reopening your business with respect to commercial litigation or potential consumer liability. So this slide just shows, with respect to the Restore Illinois guidelines, some of those specific guidelines that are specific to customers and invitees. And what I'll say about this, without going through these in any detail, is that these are things that your businesses will want to follow closely to mitigate your risk of that potential liability with respect to any future litigation, commercial litigation from these consumers or invitees. So some of the buckets that where we expect to see kind of a slew of potential litigation coming through. We've already seen a ton of claims during the closures with respect to the cruise companies, refunds issued by airlines, ticket providers, concert venues. Universities have all been sued for, tuition refunds. But I think we're going to see those similar claims continuing as businesses reopen, as well as kind of a new buckets of claims. And I'll go over some of those. So one of the big ones is going to be negligence claims. The general principles of premises liability require businesses to exercise reasonable care to protect their invitees. So that means that failure to follow the guidelines that are being put out, failure to implement the procedures that are being suggested can suggest perhaps a business is operating under a certain level of or a certain standard of care. And that will open yourselves up to potential negligence claims. So you want to make sure that you're continually following those guidelines, making sure that your businesses are paying attention to how those guidelines might apply to people that are coming onto their premises, whether it's a delivery person or a mailman, as well as the customers that you're bringing in or visitors that are coming. Another bucket that we're expecting to see is breach of contract claims. So we're already seeing the breach of contract claims for membership and subscription services and refunds and things of the like. One thing you want to remember and what you want to look at as you perhaps modify your activities or modify what you're offering through these types of services is, are you providing the essence of what you're contractually obligated to provide? So what is the basis of that contract, and what is it you are agreeing to provide? And are you still providing that, or are you limiting in that in some way? And by limiting it, do you need to either adjust the amount you're charging or have sort of other conversation with your the people that are subscribing to those services? We're also likely going to see a large uptick in consumer fraud class actions. The FTC is tracking these and already sending out many COVID-related FTC enforcement letters. They, as of yesterday, reported over 61,000 customer or consumer complaints, mostly related to the travel industry and online shopping with respect to returns, labeling, price gouging. But as businesses reopen, we are going to expect to see that increase. So some of the things you want to think about with respect to potential consumer claims as you reopen is that under many consumer fraud acts, including Illinois', deceptive and unfair is defined very, very broadly. And it is very easy for a plaintiff's firm to make a case under those claims with respect to either price gouging or mislabeling or misrepresentations. And those are often coming in the form of class actions. In addition, many states have very, very strict statutes over pricing of certain items and price gouging. So you want to make sure you're familiar with those statutes with respect to what it is you're able to do when you're trying to adjust prices because your products are perhaps more in demand or more pricey. Also, you want to think about the TCPA as businesses reopen and they're trying to reach out to their consumer databases or trying to do things more hands-off, right? Making reservations and sending updates via text message or sending advertisements via text message. Know that there is very, very strict compliance rules under the TCPA. And again, we would see those in the form of class actions because there are very significant statutory damages that go along with each TCPA violation. I'll note that as of right now, with respect to the biometrics, it is unlikely that temperature checks are going to be covered by the Illinois Biometric Privacy Act, but as new technology comes out, you want to pay attention to whether or not that technology is collecting any sort of physiological data and what's happening with that, because the Illinois Biometric Privacy Act is a very popular avenue for plaintiffs' firms to sue under. So what can we do to mitigate the risks, right? First and foremost, you want to pay attention to your brand and reputation. That doesn't necessarily mitigate the risks, but you should make decisions over how much these types of these actions, what you're doing with respect to refunds, membership services, are going to be publicized in the media, and whether or not the decisions you're making are going to affect your brand and reputation. But similar to what everyone has talked about today, provide notices, provide disclosures, revisit contracts, right? Is now the time to add an arbitration clause? Are there class action waivers? Can you add a force majeure clause? Can you negotiate a force majeure clause that's more specific to viruses? Those types of things we should be looking at now. And then you want to document, prepare policies, action plans, and evolve, right? As the guidance starts to evolve and continues to evolve, originally face masks were not required, now they are. Companies need to continue to evolve with those in order to mitigate the risk. And then I'll cover this very quickly so that you guys can hear from my colleague Toby about real estate, but property and business interruption insurance is certainly something that many people have likely already considered. And so one of the things that I want to point out with respect to that, just as Susie did, is that it's going to be very, very specific with respect to the policy language. And so what constitutes physical loss is often the key question. Keep in mind that some business interruption insurance coverage also has coverage with respect to governmental decisions that are causing business interruption. Now, typically those are coming in the form of, a city shutting down a section or blocking off a section of a city for purposes of a hurricane or an earthquake, but certainly you should look at the specific language of your policy to see if some of the stay-at-home orders might affect your coverage policy with respect to having to shut down your business post the COVID pandemic, for the stay-at-home orders. In particular, I'll note that a Paris court just ordered an insurance company to pay a restaurant for 2 months of losses during the COVID crisis due to a contract that didn't require physical damage, but was based on the city's order to shut down that business. So it is something you want to look at and consider. Also, with respect to the consumer claims or the premises liability claims, you want to take a look at your general liability coverage. Those are to respond to claims against the business. Now, I'll note two things here, right? One, certain policies might contain a virus exclusion. It's unlikely. Certainly they all will now, but you want to check for that. Two, you want to look for whether or not, the insurance will be dependent on whether or not the harm done was an accident or reasonably foreseeable. So if you do not continue to evolve with the guidance that is being provided, it is likely that an insurance carrier might deny your coverage because now understanding that someone might get sick if you don't have the right cleaning protocols in place is something that is now foreseeable. So with that, I will introduce one polling question with respect to this. We'd be interested to know whether or not you have or intend to seek business interruption coverage in light of the losses associated with COVID-19, and I will turn it over to my colleague Toby to talk about real estate guidance.
Thanks, Christine. So I'm going to discuss how landlords and tenants can effectively strategize and implement their effective reopening. So the first step is really to plan. For those of you who have already started this, that's fantastic, and for those of you who have not, it's never too late to sit down and come up with an effective plan. So the first step is really to select your reopening team, consider what safety and protective measures are going to be required, review all planned new procedures and protocols, any operational changes that you need, and potential legal exposures. Be sure at this point to consult with legal counsel and get up to speed on any new state, local, and federal laws which may regulate your reopening. Be sure to review your leases and your license agreements, your vendor contracts, and understand what those documents say with respect to rights and obligations. And be sure to consult with your insurance consultant. As Susie and Christine mentioned, these policies can be very specific, so make sure you know what is covered and what is not. Also, effectively communicate your reopening protocols clearly with your tenants, your vendors, your contractors, and to the extent necessary to the public. Be prepared for tenant questions on your reopening plans and your protocols. It's important to stay informed throughout this process. You want to designate 1 or 2 team members to stay current on federal, state, and local mandates and recommendations. And if we've learned one thing throughout this entire crisis, it's that we have to be flexible. Information is constantly changing, so be prepared for ongoing modifications to your plan. Also, with respect to costs, who should bear the cost of the new safety measures that have to be put in place? Should it be a landlord? Should it be tenants? Or are these costs things that we can pass through to customers? Let's talk for a minute about the specific steps that landlords can take to prepare. With respect to safety and personal protective equipment, they were going to want to require building personnel, vendors, and contractors to wear masks whenever within 6 feet of others. To the extent possible, consider amending existing service agreements to include this requirement. For social distancing, you're going to want to consider various categories, the first of which is the tenants, vendors, and contractors. You're going to want to limit building occupancy and recommend tenants limit the number of visitors. So work with your vendors and your contractors, too, to limit the number of personnel overall in the building. Next, with respect to a landlord's own employees and brokers who may be in the building, it's important to limit the number of people at meetings and use virtual meetings whenever possible, including virtual showings of the building. Remember that Illinois guidelines state that all employees who can work from home should continue to do so. Lastly, we got a very common question about elevators and how to effectively move people throughout the building. You're going to want to consider cab sizes, the number of building floors, and daily number of tenants and visitors when determining the number of people allowed in an elevator. You're going to want to queue marks in elevator lobbies to keep people 6 feet apart, but also designate certain elevators to go up and to travel down to avoid longer ride times and wait times in the lobbies. You're going to want to take practical steps with respect to common areas and amenities. Increase space between lobby furniture and or reduce seating. You want to close amenity spaces when possible in accordance with leases and license agreements. The Illinois guidelines provide that indoor food courts and shopping malls are to remove seating or to render it inaccessible for public use. And with respect to water fountains, those should be made unavailable except for touchless water bottle refill stations in both office and retail settings. You're going to want to provide hand sanitizer stations at building entrances, elevators, and common areas. With respect to security and building access, you want to have separate paths for travel in and travel out and limit access points, one entrance and one exit. And it was touched on earlier, but we want to stress the importance of signage to display signage with face covering requirements, social distancing, and various cleaning protocols. Next, for tenants, what can they do? And how do they decide which office to open? The first is to look at the economic analysis. Look at pre-crisis performance versus reopening projections. Be sure to assess the cost of lease termination should a given location no longer prove viable post-COVID. Do the costs of post-COVID retrofits render a site no longer financially viable? We also need to make sure to take into account co-tenancy considerations. If you're a retail tenant, have COVID-19 closures triggered co-tenancy provisions in your portfolio? If so, you want to analyze what steps you must take and the required timing to claim the relief provided under your lease. You want to evaluate your relationship with your landlord. Is this a multi-site landlord with cross-default considerations? Have you not paid or short paid April and or May rent for this location and or other locations leased from this landlord? If so, has a strategy been devised to restore the relationship with the landlord and therefore increase your potential for future negotiations and rent relief or potential term extension? Be sure to consider subleases, assignments, give back, and repurposing opportunities. Is this a site where it might make sense to seek an alternative user or convert a support use? Do you have rights in your lease to give back square footage or shrink your footprint? And what are your rights under your lease to assign the lease or sublease the space, either all of it or a portion of it? If landlord consent is required, what hoops do you have to jump through, and what timing is embedded in the consent provisions? Is there any deemed consent provision that you can rely on in order to aid you in this purpose? It's important, too, that tenants plan for social distancing. These fall into three main categories: spacing, repurposing, and general occupancy control. You want to plan spacing in workspaces, passive travel, and common spaces like hallways, lobbies, office conference rooms, open workspaces and kitchens, and in-store aisles and checkout lines. In the industrial setting, you want to redesign or slow down production lines to allow more space between employees. Repurposing, you want to repurpose conference rooms and lunchrooms and other communal spaces to allow more distance, or close them altogether, or perhaps consider partitioning common spaces to convert them into private work areas in order to avoid shared offices. You want to consider certain occupancy controls, like changing work schedules or shifts to limit the number of employees physically present in a specific location. Consider staggering of meal periods and rest breaks, and consider permitting employees to eat at their workstations. Be careful to consider state and local laws, as these may impact your options. And if feasible, you want to consider virtual meetings and to continue to work from home in accordance with the Illinois guidelines. We're now going to pause for another poll question. As we've been seeing a number of delays in supply chain, what has usually shipped in 2 days is now taking somewhere between 10 to 14 days, and we're curious if you guys are all seeing the same thing. So what lengths of delays are you seeing in your supply chain? As you reopen, be sure to access your supply needs. Explore options for sourcing additional supplies required for business operations and health and safety supplies. Assess how to best leverage existing relationships with vendors, or whether you need to reach out and develop new relationships. Create a plan for how you will source and distribute cleaning supplies and PPE, accounting for existing and future shortages and existing delays. Establish a protocol to monitor this on a frequent basis as rules and health guidance continue to change. If you have international operations, consider current challenges with respect to shipping certain products across borders. You may have to modify your traditional supply chain routing. On a logistics standpoint, evaluate current situation as it relates to ports of entry and trucking logistics for your products. Will this impact your ability to timely resupply both now and in the medium term? And keep an eye out for future legislation which might have the effect of requiring quarantine for cross-state travel lines, and that could thereby disrupt the supply chain even further. Next, we're going to just touch on some lease considerations for both landlords and tenants. I cannot stress enough how important it is to review your lease and understand what type of leverage you may have as a tenant or as a landlord. Understand the effect of force majeure provisions in the lease and address those if possible. Examine the requirements for tenant build-outs and how slow permitting has affected the ability to meet construction and delivery deadlines. Landlords can certainly ask for tolling of their delivery period for COVID-19 issues, but tenants are not going to be expected to wait forever. If a tenant's lease has a continuous operation covenant, you need to determine whether social distancing and other requirements make it impractical or unprofitable to operate. And if you have not already done so, it's important to address non-payment and restructuring of payment structure and an extended term. You want to review what's required in the lease with respect to common areas and whether the landlord is required to provide enhanced cleaning and hot water, for example, or availability of certain common amenities, and whether the closures of those areas affect the operation of your business or whether perhaps rent credits are appropriate. Now we're going to pause for our last poll question. What type of relief, if any, did you provide or receive during April and May? We're curious to know if folks have received rent abatement or rent reduction, if their terms have been extended, or some combination of the above. We also want to urge everyone to consider various ADA considerations. The ADA requirements for points of access to maintain at least one accessible entrance and the width of entry queues are important. Also consider when requiring face masks, whether you want to use alternative methods for communication with customers and tenants, such as whiteboards and pens. Lastly, I just want to circle back to an issue that we received word on earlier this morning. We learned that the Chicago Department of Buildings has established rules for construction workers requiring both an ID and a letter from employer stating that they are entering the city to perform essential services. We understand that with respect to the current closures in the downtown business area, this letter must be shown at the checkpoints at either Chicago and Halsted or in Chinatown and State and Cermak, and this is expected to take effect tomorrow. We're not yet certain whether such regulation will apply to industries other than construction, but we encourage employers to reach out to council concerning the latest regulation because of the various riots in Chicago and the associated closure. And I see that, we've sort of run short on time. I know that a number of you have submitted questions throughout the presentation. We will plan to answer those questions via email, and I want to thank everyone for dialing in, as well as my co-presenters today.
Toby, this is Susie. I just want to repeat again the CLE code, SF6562. Thank you, everybody.
Ladies and gentlemen, that does conclude today's webinar. We want to thank you for attending and have a nice afternoon.